is the best example of that. In Booker, the mandatory sentencing provisions were central to the Act, but the Court said Congress would have preferred a statute without the mandatory provision in the Act, and the Court struck that, but the rest of the sentencing guidelines remained.
I think the reason the majority said that was that they didn't think that what was essential to the Act was what had been stricken down, and that is the ability of the judge to say on his own what the punishment would be. I don't think that's a case where we excised the heart of the statute. You have another one?
There's no example.
There is no example.
There's no example that we have found that suggests the contrary.
It's really a case of first impression. I don't know another case where we have been confronted with this decision. Can you take out the heart of the Act and leave everything else?
Well, I'd like to go to the heart of the Act point in a moment, but what I would like to say is this is a huge Act with many provisions that are completely unrelated to market reforms and operate in different ways, and we think it would be extraordinary in this extraordinary Act to strike all of that down because there are many provisions and it would be too hard to...
I mean, I think it's not uncommon that Congress passes an Act and then there are many different titles, and some of the titles have nothing to do with the other titles. That's a common thing. And you're saying you've never found an instance where they're all struck out when they have nothing to do with each other. My question is, because I hear Mr. Clement saying something not too different from what you say. He talks about things at the periphery. We can't reject or accept an argument on severability because it's a lot of work for us. That's beside the point. But do you think that it's possible for you and Mr. Clement, I'm exploring this, to get together and agree on on a list of things that are, in both your opinions, peripheral? Then you would focus on those areas where one of you thinks it's peripheral and one of you thinks it's not peripheral. And at that point, it might turn out to be far fewer than we're currently imagining, at which point we could hold an argument or figure out some way, or somebody'd hold an argument and try to get those done. Is that a pipe dream, or is that
I just don't think that's realistic. The Court would be doing it without the parties, the millions of parties.
Have a conference committee report afterwards, maybe.
Yes. No, it just is not something that a court would ordinarily do. But I would like
to get back to the argument of the heart.
Yes.
Striking down the heart. Do we want half a loaf or a shelf?
Right.
I think those are the two analogies.
Right. And I would like to discuss it again in terms of the text and structure of the Act. We have very important indications from the structure of this Act that the whole thing is not supposed to fall. The most basic one is the notion that Congress would have intended the whole Act to fall if there couldn't be a minimum coverage provision is refuted by the fact that there are many, many provisions of this Act already in effect without a minimum coverage provision. 2.5 million people under 26 have gotten insurance by one of the insurance requirements. $3.2 billion.
Anticipation of the minimum coverage. That's going to bankrupt the insurance companies, if not the states, unless this minimum coverage provision comes into effect.
There's no reason to think it's going to bankrupt anyone. The costs will be set to cover those amounts.
I thought that the 26-year-olds were saying that they were healthy and didn't need insurance yesterday.
Today they're
going to bankrupt.
2.5 million people would be thrown off the insurance rolls if the Court were to say that. Congress made many changes to Medicare rates that have gone into effect for the courts to have to unwind millions of Medicare reimbursement rates. Medicare has covered 32 million preventive care visits by patients as a result of this Act.
All of that was based on the assumption that the mandate was constitutional, and if that certainly doesn't stop us from reaching our own determination on that.
What I'm saying is that it's a question of legislative intent, and we have a very fundamental indication of legislative intent that Congress did not mean the whole Act to fall if without the minimum coverage provision, because we have many provisions that are operating now without that. But there's a further indication about why the line should be drawn where I've suggested, which is the package of these particular provisions. All of the other provisions of the Act would continue to advance Congress's goal. It's the test that was articulated in Booker, but it's been said in Regan and other cases. You look to whether the other provisions can continue to advance the purposes of the Act. Here they unquestionably can. The broad public health purposes of the Act that are unrelated to the minimum coverage provision, but also the other provisions designed to enhance affordable access to affordable care. The employer responsibility provision, the credit for small businesses, which is already in effect, by the way, and affecting many small businesses.
But many people might not have, many of the people in Congress might not have voted for those provisions if the central part of this statute was not adopted. But to say that we're effectuating the intent of Congress is just unrealistic. Once you cut the guts out of it, who knows? Who knows which of them were really desired by Congress on their own and which ones weren't?
The question for the Court is Congress having passed the law, by whatever majority there might be in one house or the other, Congress having passed the law, what at that point is the legislative intent embodied in the law Congress has actually passed?
Well, that's right, but the problem is, straight from the title, we have two complementary purposes: patient protection and affordable care. And you can't look at something and say this promotes affordable care, therefore it's consistent with Congress's intent, because Congress had a balanced intent. You can't look at another provision and says this promotes patient protection without asking if it's affordable. So it seems to me if you ask what is going to promote Congress's purpose, that's just an inquiry that you can't carry out.
No, with respect, I disagree, because I think it's evident that Congress's purpose was to expand access to affordable care. It did it in discrete ways. It did it by the penalty on employers that don't offer suitable care. It did it by offering tax credits to small employers. It did it by offering tax credits to purchasers. All of those are a variety of ways that continue to further Congress's goal, and most of all, Medicaid, which is unrelated to the private insurance market altogether. And in adopting those other provisions governing employers and whatnot, Congress built on its prior experience of using the tax code, which it is for a long period of time Congress has subsidized.
I don't quite understand about the employers. You're saying Congress mandated employers to buy something that Congress itself has not contemplated? I don't understand that.
No, I mean, employer coverage. 150 million people in this country already get their insurance through their employers. What Congress did in seeking to augment that was to add a provision requiring employers to purchase insurance or
based on the assumption that the cost of those policies would be lowered by certain provisions, which are, by hypothesis, we're not sure, by hypothesis, are endowed.
No, I think it's any cost assumptions there's no indication that Congress made any cost assumptions, but there's no reason to think that the individual market, which is where the minimum coverage provision is directed, would affect that. I would like to say I pointed out why the other things would advance Congress's goal. The point here is that the package of three things would run contrary to Congress's goal if you took out the minimum coverage provision. And here's why, and this is reflected in the findings. If you take out minimum coverage but leave in the guaranteed issue and community rating, you will make matters worse. Rates will go up, and there will be fewer people covered in the individual market.
Well, if that is true, what is the difference between the guaranteed issue and community rating provisions on the one hand and other provisions that increase costs substantially for insurance companies? For example, the tax on high-cost health plans, which the economists' amicus brief said will cost $217 billion over 10 years.
Those are what Congress did not think of those things as balancing insurance companies. Insurance companies are participants in the market for Medicaid and other things.
But you're saying we have the expertise to make the inquiry you want us to make, i.e. the guaranteed issue, but not the expertise that Justice Alito's question suggests we must make.
Well,
I just don't understand your position.
that's because I think this Court's function is to look at the text and structure and legislative history of the law that Congress enacted, not the financial, not a financial balance sheet, which doesn't appear anywhere in the law. And just
you're relying on Congress's quite explicitly tying these three things together.
And it's not just the text of the Act, but the background of the Act, the experience in the states, the testimony of the National Association of Insurance Commissioners. That's the problem Congress was addressing. There was a shifting of present actuarial risks in that market that Congress wanted to correct. And if you took the minimum coverage provision out and left the other two provisions in, there would be laid on top of the existing shifting of present actuarial risks an additional one, because the uninsured would know that they would have guaranteed access to insurance whenever they became sick. It would make the adverse selection in that market problem even worse. And so in Congress trying to come up with a market-based solution to control rates in that market has adopted something that would work to control costs by guaranteed issue and community rating. But if you take out the minimum coverage, that won't work. That was Congress's assumption, again shown by the text and legislative history of this provision. And that's why we think those things rise or fall in a package, because they cut against what Congress was trying to do. All of the other provisions would actually increase access to affordable care and would have advantageous effects on price. Again, Congress was invoking its traditional use of the tax code, which has long subsidized insurance through employers, has used that to impose a tax penalty on employers, to give tax credits. This is traditional stuff that Congress has done. And the other thing Congress has done, those pre-existing laws had their own protections for guaranteed issue and community rating effectively within the large employer plans. They can't discriminate among people. They can't charge different rates. What Congress was doing that in the other market. If it can't, that's all that should be struck from the Act.
Thank you, Mr. Kneedler. Mr. Farr?
Mr. Chief Justice, and may it please the Court. At the outset, I would just like to say I think that the government's position in this case, that the community rating and guaranteed issue provision ought to be struck down, is an example of the best driving out the good. Because even without the minimum coverage provision, those two provisions, guaranteed issue and community rating, will still open insurance markets to millions of people that were excluded under the prior system, and for millions of people will lower prices which were raised high under the old system because of their poor health. So even though the system is not going to work precisely as Congress wanted, it would certainly serve central goals that Congress had of expanding coverage for people who were unable to get coverage or unable to get it at affordable prices. So when the government...
One of the points that Mr. Kneedler made is that the price won't be affordable because he spoke of the adverse selection problem, that there will be so fewer people in there, the insurance companies are going to have to raise the premiums. So it's nice that Congress made it possible for more people to be covered, but the reality is they won't, because they won't be able to afford the premium.
Well, Justice Ginsburg, let me say two things about that. First of all, when we talk about premiums becoming less affordable, it's very important to keep in mind different groups of people, because it is not something that applies accurately to everybody. For people who were not able to get insurance before, obviously their insurance beforehand the price was essentially infinite. They were not able to get it at any price. They will now be able to get it at a price that they can afford.